Thank you very much, Wayne. Oh, you've disappeared. It's wonderful to hear how your own work, people are interacting with it. I've got to say, and although I say it's my own work, it honestly was a result of interacting with the communities which I was dealing with. It would not have been the same work if I'd dealt with, and you probably get a sense of that when reading it, if I'd only dealt with the law and sat in a library, was speaking with people, having been a practitioner beforehand, speaking with people and getting a sense of what they want, not what I want to impose upon them as a solution or what their grievances are. That was really important in informing that work. And in some ways, some of the things that I'll be speaking about today and what I'll be looking at, and hopefully will be a framework for the rest of the panellists, although it's very much a legal perspective that I'm looking at, it will provide a background to the way in which, and I'll be looking at Indigenous peoples, specifically because my work covers a lot of that, not speaking on behalf of Indigenous peoples, but seeing how their actions in the field have informed my area of law, of international law, and specifically the protection of cultural heritage. What I'm looking at today is how reparations in the human rights law context has been dealt with, specifically in relation to cultural loss. It's really, really interesting, both in relation to, as you can imagine, for Indigenous communities, ironically, and it's probably not ironic, it was deliberate, that what was being targeted was specifically their cultures. And even when it was land that was being removed, as many of us will know, land is integral to Indigenous people's ways of understanding the world and of understanding themselves and their communities. So when we deal with cultural loss with Indigenous peoples, it is very, very much a whole of community, whole of person claim. So, and there's a reason why it's significant. So when cultures and their disappearance through destruction and assimilation, as I said, was central to the colonial process, and specifically nation building by settler states, this had a particularly devastating impact on Indigenous peoples because of the way that they understand culture. So it's holistic, symbiotic, collective and intergenerational in character. And so, and as I would argue that, and I'm sure that many other speakers will make this claim today, although we talk about reparations for historic wrongs, I would argue, and indeed certainly Indigenous peoples would argue, that what we're talking about are not historic wrongs but ongoing wrongs. Yeah. And this is very, very important because of the way that the law functions. So there's this ongoing impact of colonisation, assimilation and discriminatory practices that means that, as I said, they're not simply historic injustices. And this is what makes Indigenous claims before various international human rights and regional tribunals significant, specifically in relation to cultural loss. So my paper, and I won't go into the detail that I would otherwise, is emphasising this notion that it is not about past wrongs, that they are ongoing wrongs. So unlike, and Indigenous peoples, and you see this through various UN documents, don't talk about decolonisation. For these communities, decolonisation hasn't happened. Yeah. So this idea of decolonisation being an incomplete process and indeed independence not being gained by them, and this is why they emphasise the idea of the right to self-determination, their ability to determine how and in what capacity their cultures can develop and be accessed by others, certainly. So the paper, or my presentation, is divided into three parts. The first looks at, and very briefly, I'm conscious of the time, how culture is conceived by these communities. Secondly, how the idea of cultural loss is structured by way of claims in international law and human rights law. And then finally, I look at the specific heads of damage in international law. What I would maintain, this is what is really interesting, it goes back to what I mentioned when I first opened my talk, is that my work is driven by, and indeed law is driven by, some of the most interesting cases are the gaps in the law. Yeah, so the ready concession that there are limitations in the law, and what lawyers, hopefully the ones that are hopefully doing their job properly and have their hearts in the right place, one hopes, are trying to ameliorate those gaps in a way that benefits the people who are victims of gross violations of human rights or international humanitarian law. So what I would argue is that what is interesting is that these communities are themselves having a transformative impact on the law itself, which is both beneficial for the communities themselves, one hopes in the long term, but also for all the community. The international community and also national communities. Their claims are literally transforming and changing the law and addressing those gaps. And so before I move on to that, and as again, I'm conscious of the time, I would say that relationship is the same, and I'm talking from the point of view of a lawyer. I know when I mentioned that I was a lawyer to somebody who's presenting tomorrow, his face fell. From the point of view of even, I would challenge museums in relation to that as well. Be open to the transformative impact of what Indigenous communities and the communities that are represented in those collections can do for the life of a museum and changing the way that a museum is understood. It's not simply a collection. There's wonderful examples, certainly in my area, in Australian context, by where museum officials were ready to negotiate restitution claims and then have ongoing relationships with those communities, and the nature of those collections change. A lot of the collections were collected at a time when there was very little information by way of provenance. They have no idea what these objects mean or represent, and they simply have become much more alive. I'm giving just the positive. Certainly there's more problematic aspects to this, but being open to the transformative impact of restitution claims or having ongoing relationships with the communities represented by those collections, I think is vitally important for the future of museums, as it is for law. So first off, and again, this is very, very schematic, in relation to how culture is defined in the Indigenous context, it is very different to the way that it is defined in international law for the protection of cultural heritage. If you look at the general treaties in this area, as I mentioned, what is significant is their emphasis on the holistic nature. So if you look at the treaties in this area, it looks at movable heritage, immovable heritage, such as the World Heritage Convention, which is sites, and then others will look at intangible heritage, and they're almost exclusive. That's changing slowly, but this does not make sense in the Indigenous context. And also this central idea of land and resources of that land is also vitally important. I'll talk to that more generally soon. And then the idea of collective or intergenerational custodianship, not ownership. So if you look at a lot of the instruments in this field, they talk about material culture as property. This is unknown in the Indigenous context. And the importance of their own custom and law in governing how their culture shall be treated by others and by their own communities. These are all elements of the way we understand, or they understand their culture, which was deliberately and significantly subverted by the colonial context and the resulting dispossession. All of those aspects of their culture was disrupted. I'd like to speak to, and this is probably what distinguishes it from, and I certainly don't profess to have any knowledge of the reparation claims in the context of slavery and slave descendants, is the emphasis on land. So when we talk about dispossession, is this vital emphasis on knowing and living in the country where they still continue to be dispossessed is vitally important to the way of understanding Indigenous claims, both in relation to culture and so forth. So, and you see this, and I'll refer to the UN Declaration on the Rights of Indigenous Peoples. They emphasise the importance of land in relation to their ongoing material and cultural understanding of themselves and for future generations. So that importance of land is integral. Now, I'd like to look at the bases for claims for for cultural loss in international law very briefly again. These are, again, very legalistic. The reason I raise them is I think it's very important when people are framing claims for reparations and so forth that they understand the background to which how the law has developed. So there are three aspects to this, particularly in the UN Declaration, including genocide and the removal of Indigenous children from their families and communities. Next, the idea of ethnocide and cultural genocide, and particularly the disposition of land and resources. And then finally, non-discrimination in human rights law. And here, the emphasis on self-determination in respect of, including cultural matters. So the UN Declaration on the Rights of Indigenous Peoples specifically reiterates Article 2 of the Genocide Convention as being applicable to Indigenous peoples, both as individuals and as communities. What is interesting here is that they also replicate, which is the only aspect of the definition of genocide in the 1948 Genocide Convention, which refers to the cultural aspects of genocide, which is the removal of children. And of course, as many of you know, this is no coincidence for Indigenous communities, certainly in Australia, Canada and the United States. During the negotiations for the UN Declaration, there was resistance for the inclusion of this, particularly making specific that was to cover individuals and groups, but it has been included in that way, and certainly we see this being a live issue again in the Australian context, and I'm happy to speak to that when we have questions, and more recently in the Canadian context with the Commission releasing its final report, the Truth and Reconciliation Commission. What is interesting about the UN Declaration is that it also specifically refers to ethnocide, or what is otherwise known as cultural genocide. Again, there was strong resistance, and there was specific resistance in the lead up to the Genocide Convention in 1948 to the inclusion of anything like this by countries, including settler states, because of the fear of criticism of assimilation policies. And so it is interesting that it is included here, and the declaration itself refers to specific instances of what amounts to ethnocide, including dispossession of land and territories, forced removal of populations and so forth. So the instrument itself includes this and makes a significant development on the Genocide Convention itself. And the final head of claim is the human rights aspect, and particularly self-determination. So what we have here, and if you look at the UN Declaration on the Rights of Indigenous Peoples, they specifically and deliberately replicate what is in the UN Charter, the two international covenants on human rights, specifically Common Article 1, as being applicable to Indigenous peoples, that is, the right to self-determination. And they make clear that this extends to any aspects of their culture. So they're the three heads of claims. I'd like to now refer to how Indigenous communities have dealt with what are traditional heads of reparations under international law. Now, these heads, I've got to preface by saying the way that they've been articulated is in relation to state claims previously. There has now been an evolution in relation to human rights law, and there's been a lot of work done here in relation to the way in which human rights courts have interpreted these heads of damage or reparations to address gross and systematic violations of human rights. What I would like to look at here in our context today is how this is being transformed in relation to claims concerning cultural loss. So the first head of damage is restitution, and that's a term of art in international law, and I'll explain this. So the whole point of reparations in international law is to bring the injured party to the position that they would have been if the wrongful act had not occurred. Now, and I'll explain why this is problematic, and for many of you it will already be patently obvious why it's problematic, but I'll also bring it into context work done by feminist legal scholars about the idea not of reparations but of transformative justice. Yeah. So the heads of damage in relation to reparations in international law are restitution, compensation, rehabilitation, satisfaction and guarantees of non-reoccurrence. As I said, each one of those has been specifically interpreted and extended by claims by Indigenous peoples, specifically for cultural loss. So in relation to restitution, this is the primary head of reparations under international law. So you will only progress to the other heads of reparations if restitution is impossible or inadequate, yeah, and then others are considered. However, I would argue, and others certainly have, where it involves a preemptory norm, such as the right to self-determination, and where breach of that would by its definition be an ongoing character, then restitution is tied to the idea of cessation of the wrongful act. Yeah. What I would argue, and this is probably why restitution is so fundamentally disturbing for settler states or states which are subject to these claims, is that they go to the very heart of them having to confront their colonial and assimilationist policies. So there are three aspects to this. I'm conscious of this at the time. Do I have about 10 minutes? Okay. Three junctures as which the UN Declaration on the Rights of Indigenous Peoples refers to restitution specifically. So it covers cultural and religious property or heritage, ancestral remains and ceremonial objects, and land. Now, many of you will be familiar, and I won't go into this in any great detail because I think the other heads of damage are probably much more interesting for purposes of our discussion, is that the UN Declaration refers specifically to the right to restitution, initially in the earlier drafts as a right, as a standalone right, and then as it was being renegotiated amongst states, it becomes part of the remedy, that is, the reparations to a wrongful act, rather than a standalone right. Also, they refer to the need to, and the right of Indigenous peoples to the return of human remains or ancestral remains, as they refer to them as. And this is something that is not unfamiliar to international human rights law. So this right in relation, you see the Inter-American Court talking about this and acknowledging the right of Indigenous communities and groups to have the burial and care of ancestral remains as being a core component of their cultural and religious observance. And that in other cases, noting that it is of an intergenerational nature, that is, performing of customary obligations, and that the community continues to suffer a significant ongoing injury until that is rectified. There are certainly examples, and I'm happy again to talk about this when we look at when we have a discussion about examples in certain settler states, and indeed an agreement between Australia and the United Kingdom, in the United States under legislation, in Canada and Australia under a voluntary code for the restitution of ancestral remains and also significant cultural objects or sacred objects. Now, under the declaration itself, it extends the idea of restitution to intangible heritage as well. So the idea of designs, ceremonies, technologies and so forth not being able to be accessed without their free, prior and informed consent, and the idea of benefit sharing. This is significant, and I will talk to this in relation to accessing archives and other ancillary materials, is because of the nature of assimilation and the destruction of communities' cultural practices. So restitution goes to things like archives, genealogies and photographic collections in a way that will allow them, that is the communities, Indigenous communities, to reconstruct individual and collective identities, to re-establish familial and communal connections and reinforcing title to land. And then finally, in relation to restitution, is this idea of the return of land and sites, both in relation to sacred sites, but also land itself, because of its integral nature to Indigenous understandings of their own culture and spirituality, and indeed themselves and their communities. And there are various aspects of addressing this. Now I'll move on to compensation, and here I specifically, and this is the law specifically refers to compensation as monetary compensation, is only to be addressed when restitution is not possible, yeah, or making reparations complete. So the purpose of this is to be corrective and rehabilitative and not punitive. And as I said, it's intended to make full reparations. The examples given here, and when addressing particularly assimilationist practices, is to enable compensation to address physical and mental harm, lost opportunities such as employment and education, social benefits, other material losses such as loss of earnings, medical and medical treatment, psychological and social services. So it's this more rounded idea of reparations. The next head, which is rehabilitation, you get a sense now of how broad this idea of reparations is, not simply restitution, is the rehabilitation being a mechanism by which they are intending to have the individual, family, local community, or indeed the society as a whole heal, acknowledge the wrong and integrate the individual who has been subject to the harm. So in the case of serious human rights violations, there is acknowledgement that this is a massive trauma that can be lifelong and multi-generational. So what is often covered by this includes medical and psychological care and legal and social services. We have the Inter-American Court addressing things such as the provision of health, housing and educational programs of victims of massacres and so forth. Again, and this becomes even broader, under the head of satisfaction as a head of reparations. Although this is not covered by the UN Declaration of the Rights of Indigenous Peoples, it's quite clear that it is something that can be encompassed by it under Article 40, is that it is designed to address a moral injury and provide full reparations in addition to compensatory and non-monetary remedies. So what here is encompassed is the right to know, including a public apology, monuments and commemorations, the inclusion of an accurate account of the violations into legal training or educational materials, and the right to justice, so the cessation of the continuing violation or judicial and administrative sanctions against the people who were the violators. This right to know is individual and collective. It covers both victims and their families, and it covers, for example, where people have disappeared or died, the context in which they met their fate. So it's designed to restore dignity, the reputation and the rights of the individual and persons closely connected with that individual. The right to know can, as I said, be both collective and societal. So it is tied to the duty to preserve memory. So that human rights violations are protected by knowledge of by a community's historic understanding of a history of oppression and how heritage forms part of that, and addressing collective memory so that it guards against revisionist or negationist arguments. And obviously and clearly, access to archives and so forth is fundamental to this. And the final head, and this is where I will end, and I think this is probably the most transformative, is the guarantee on non-repetition or non-reoccurrence, because it has the most far-reaching impact potentially. So the remedy is designed to ensure that victims do not suffer the violations of their rights in the future, and to foster and sustain respect for human rights within the broader society. So it is not simply confined to the victims themselves, but goes beyond to the entire society. The UN Declaration on the Rights of Indigenous Peoples say that communities or states, when addressing reparations in relation to Indigenous peoples, must consult with them and are bound to this because of the right to self-determination, amongst other things. So the UN Declaration refers to the right of Indigenous peoples to freely determine their relationship with states in a spirit of coexistence, mutual benefit and full respect. Now this has taken many forms, including probably the least of impact by way of on the state itself is the introduction of distinctive national legislative and administrative regulations and institutions to address cultural loss and provide autonomy in relation to cultural matters for Indigenous communities. The next is a form of home rule or autonomy whereby they are able to create their own structures and self-government. So that's discrete within the state. And perhaps the most transformative, though, is where, and this is often where there is a majority Indigenous population on the territory, is the finalisation of agreements or treaty between communities where there is a transformation of existing national, political and civil, economic, social and cultural structures through constitutional and legal reform, the consultation and cooperation of Indigenous peoples and the re-education of the entire population. and some of you may well be aware of the examples of this, and some of it going off the rails, unfortunately, in that it's not been fully realised. But that final example has the most transformative effect of ensuring, I think, some of the things that we wish to address here, of not simply talking about it being a physical act of return or restitution or monetary compensation, but transforming the entire society by way of these claims. So thank you.
Great.